翻今日嘅會議啦。下一位發問嘅係陳志全議員，第一輪嘅啫。
係唔該主席。嗱，主席文件裏邊第9段就話，除了考慮文章上面嘅一籃子因素之外咧，司法人員嘅申常會咧秉持維護司法獨立嘅原則作為審議嘅基礎，喺履行職能嘅時候，司法人員申常會嘅引導原則係司法人員薪酬應足以吸引並挽留人才。
In order to maintain an effective and independent judicial system which upholds the rule of law and commands confidence within and outside Hong Kong, maintaining an independent judiciary of the highest integrity is of utmost importance. Well, if you ask me, the so-called independent judiciary hinges upon we're at the mercy of the Central People's or the CCP. Now, if CCP decides to take back this independent judicial independence, then we have little left. And when this is done, this will shock or will undermine so-called independent judiciary. I agree with Mr. Eddie G in that we face challenges to our rule of law. Should we still continue to approve funding for expansion of court buildings and to provide money for pay rise for the judiciary? Now, I will set aside the question of expansion of courtrooms first. Now, for the judiciary, no matter how our rule of law has been undermined, we cannot boycott our courts. When you are charged, you have to go through court procedures. All you can beg is that we still have high-quality judicial officers, and that the poor ones will not replace the good ones. I still believe in the quality and caliber of our judicial officers. Their attitude and position are separate matters, but I believe in their caliber. I have seen or expect judicial officers may feel frustrated and want to leave the judiciary. So when the judicial committee discussed this, there was still not the national security law, and I think back then they would not discuss whether some judicial officers were frustrated and were planning to leave. But this is an objective fact. I think perhaps you should pay our judicial officers higher so that our very high caliber judicial officers can be compensated for the grievance they feel. Perhaps we should have this flexibility, and we should offer a more attractive salary to retain talents. Now, for Zhang Kuineng, the CJ was appointed, and then a vote against it or to abstain was regarded as disrespect to the CJ, to the future CJ, according to Mrs. Carrie Lam. So, Ms. Lam, in the judicial pay, of course, the salary is just one thing. We also have the conditions of service and so forth. So every year there is an annual exercise to discuss the annual pay rise. Every 5 years there is a baseline study. 5 years ago, when the baseline study was done, it was found that judges at certain levels were there was this tendency that the gap between our judges and their counterparts in the private sector were widening, and so there was a revision of 6% after the benchmark studies. Now, for district judges of district courts and magistrates, says there was a 4% increase across the board. And then there was a review of the conditions of service, such as remuneration other than the salary was improved. All in all, we hope that we can provide a package sufficiently attractive to retain talents. And last year, we also extended the retirement age of our judicial officers. That would be helpful to a certain extent. Mr. Ray Chen, can you please turn on the microphone for him? Well, Ms. Leung did not fall into my discussion for the competitiveness of your judicial pay. Well, if the private sector is more attractive, of course, you should revise that pay. But I was talking about the push as well, the push factor. But I'll wait for my second round.
I'm also very concerned about the present proposal. The background, of course, is that under the influence of the national security law, what should the judicial officers do? Coming back to the question of salaries, as far as salaries are concerned, I understand that under the national security law, it is stipulated that the CE can designate judges from a list. And these judges could be incumbent judges or deputy judges and so on. So I'd like you to confirm whether or not, in dealing with cases concerning the national security law and among the judges selected by the CE, will their salaries be the same as those of the other judges? Is there an official paper to inform you of that? My understanding is that our present proposal, if our proposal today were approved, it would apply to all judges appointed by the CE pursuant to Section 88 of the Basic Law, including the designated pool of judges to deal with the national security cases. So the CE can actually select judges. This is really unprecedented. I understand that even among common law jurisdictions, this is very rare. It could be, the first of its kind historically. So for the deputy judges and the specially appointed judges who are appointed to the list of judges dealing with national security cases, who are these judges roughly? For these specially selected judges, they could be people like Mr. Martin Liu or Mr. Or then people may doubt that, have doubts. So do you have? Well, I don't have any such news yet. So you don't know, therefore, that whether they will be paid the same amount of salaries as the other judges. Now, if I may now continue. According to your paper, of course, the salary level is determined pursuant to recommendation of the Judicial Officers Commission, and you say that you will take into consideration a basket of factors, and one of the factors being, whether it's about the recruitment and retention in the judiciary. I noticed in the news an hour ago that Mr. Jeffrey Ma, the Chief Justice, have issued a statement. He is concerned that under the national security law, when the CE can pick judges, he said there shouldn't be any political considerations, that the CE should only base its decision on the expertise and the capability of the judges. Of course, if the CE were allowed to select the judges, of course, the CE will not know as much about the expertise of the judges as in the case of the Chief Justice. So among all the judicial officers, all the judges, will it result in the judges having doubts about the judicial system and also the existence of political factors? Will such concerns affect your recruitment and retention of the judges? Thank you. Mr. Hui cited the Chief Justice statement. I don't think it's in my position to comment further on that. I'm not referring to the content, but I can, roughly talk about the principal concern. Mr. Hui is asking how these judges are appointed. Could you hold, if I may? I think the director is wasting my time. My question is that under the influence of the national security law, will it affect the retention and the recruitment of judges? According to the information provided by the judiciary, given the present manpower shortage, they will continue with the open recruitment. So far, according to the information available, the results of the recruitment is positive. It is just that in the High Court and the Court of First Instance, such posts are more difficult to recruit, basically because of the discrepancy in the salaries between the judiciary and the private sector. Of course, I would also agree that we should not only consider the salaries of the judicial officers, we should also consider the job satisfaction and also the culture of the judiciary. Of course, this has something to do with the national security law, but I'm not directly asking about the content of that law. I think the Chapter 1 of Section 3 of the National Security Law says that the administration, the judiciary, the executive judiciary, and the legislature of the SAR should follow the rules, the National Security Law to prevent and to censure any acts threatening national security. In the same chapter, Section 6, it is stipulated that for Hong Kong residents participating in elections or taking up public offices, they should sign relevant documents to confirm and to swear their allegiance to the basic law and the SAR of Hong Kong. Take the last legislative election, for example. In that process, members were asked to sign, candidates were asked to sign documents. It is expected that candidates will be required to do the same in the coming election. Since the national security law stipulates that the judiciary and also public officers have to sign documents to confirm their endeavor to prevent, stop, and to punish any acts threatening national security. So my question is that whether the judiciary will, I think for the judges and judicial officers of different ranks, will have to sign similar, documents to confirm that they would comply with the requirements of the national security law. If they have not signed such, a document, will there be any changes in the contract? Will it be stipulated in the contract? Why did you answer these two questions first? I don't see how that is related to the salaries of judicial officers. But anyway, Ms. Leung, for all the judges in Hong Kong, according to Section 88 of the Basic Law, if they are appointed by the CE, we have to follow the Basic Law and also the Orphan Declaration Ordinance to take a judicial oath which applies to judges at all levels. They have to take an oath to swear their allegiance to the basic law, the SAR, and also they will follow the law. And also, I think all such rules apply to all judges. So that system will continue even after the enactment of the national security law. Now, will there be any changes in the text of the document and the oath itself? Because this is going to be required in the forthcoming legislative election. Ms. Leung, at the moment, all judicial officers' oath are governed by one existing ordinance. If we need to make an amendment, then we need to amend that ordinance. And that's why I'm asking, if there's a need to amend or upgrade that piece of ordinance, will there be such an arrangement? Well, I think I can follow up on that question later. My other question is that the national security law, I think in 2014, when the NPCSC endorsed the anti-espionage law, which is implemented in Hong Kong, one of the provisions referred to, acts of espionage in Hong Kong and the relevant penalties. Now, has the judiciary discussed the question of judicial officers like judges and judicial officers of all ranks for their direct family members, spouses, and children, and their nationalities? I think, family members and children of senior officers, do they need to forsake their foreign nationality to ensure their loyalty? And would that apply to judicial officers as well? Chairman, according to Article 90 of the Basic Law, other than the judges of the Supreme Court and the High Court, who must be permanent residents of Hong Kong and cannot have foreign nationalities, judges at all other ranks are not governed by that nationality rule. According to the information from the judiciary, amongst all the judges in Hong Kong, they are all local judges with rights of abode in Hong Kong. So that they'll basically follow the same system, and I don't see there is any nationality requirement for judges. Of course, there is no nationality requirement under the national security law, but the CE can pick the judges, and those with foreign nationality will not be allowed to try to sit on such cases. In section paragraph 9, you say judicial independence is very important, and that they must uphold the rule of law and command confidence within and outside Hong Kong, and maintaining an independent judiciary of the highest integrity is of utmost importance. But under the influence of the national security law, the executive can actually select the judges to hear cases. The government can decide whether or not there will be a jury. The government can even does not need the permission of the judiciary, and can actually enter premises to conduct search and intercept communication, and also require not the judges not to allow bail. The government can even, through the law, decide that the judiciary doesn't even need to bother to try the cases, and have the case be tried in the mainland. So in that case, will we still have the independence of the judiciary? Will there still be any judicial system that will have the trust and confidence of the people of Hong Kong and those of other countries? Whereas I responded to similar questions before, the national security law will not affect the independence of our judiciary. It is actually comply with the principle of maintaining the. So for the government is concerned, I don't think it will jeopardize the independence of the judiciary. Regarding the choice of judges, I've already answered that question. Well, I'm just asking a question based on your paper. You say that you need to secure the independent. You say that you need to maintain an independent and effective judicial system, and also commands confidence within and outside Hong Kong. How can you ensure that? I still believe that the independence of our judiciary is still command a high level of confidence, by people of Hong Kong and outside of Hong Kong. Ms. Ray Chan? Thank you. Some colleagues have asked about Article 44 of the National Security Law. Whether or not it's relevant to our discussion today, when I put my question, you'll know that it's relevant. Article 44 says that the CE will designate a certain number of judges to hear cases concerning national security, and the tenure of these judges will be for 1 year. My question is that for judges designated by the CE to hear certain types of cases, after she has selected such judges, during that coming year, will the judges only be required to hear such cases concerning national security? Will they only be required to hear cases concerning national security, or will they be, in a pool, and out of which they could be selected to hear such national security cases? If this is extra work for these judges, if it is an extra requirement for these judges because they have to undertake extra duties given their expertise and experience, I don't think in Hong Kong we have judges who have tried such cases concerning national security. So when they hear such cases, therefore, will they be given extra pay and allowances? This could actually be, an onerous task for these judges selected. According to overseas report, we hear that those jurisdictions will censure, judges who, certain judges of Hong Kong. I wonder whether they would involve officials and even the judges. I have not studied the coverage of these sanctions as proposed by some other countries. If there are such risks, you may need to increase the salaries of these judges, because you may have to consider giving them special allowances. Director. To answer Mr. Chen's question, under the national security law, it is stipulated the CE may designate judges. We're not saying that for each case he will designate a judge to hear one particular case. She will designate a pool of suitable judges who may be selected to hear national security cases. If they are already judges at various ranks, they are actually incumbent judges who may have to take up as to how cases. It would not be the case that if there's a new law in place that they would be pay extra salaries to hear these new cases. So if there are no national security cases, they will hear the normal cases. But when there is a national security case, then they will be selected out of a pool to hear those cases. But already yesterday there have been 10 cases concerning national security. So will it be that these judges will specifically be charged with the trying of these cases? Ms. Leung. I think this will be for the judiciary to deploy its its manpower in the light of the circumstances at the time. I understand that there will not be. So I think. So it will be like the existing judges. That is, they have to hear cases involving all kinds of laws. So if there are extra requirements of these judges, I think we're switch on the mic for Mr. Chen. So given that they have more experience and expertise, but you don't know whether they're willing to hear these cases. So in terms of the salaries, will they need to, allow some flexibility and allow more salaries for judges who are asked to hear such cases? Under the existing salary scale, there is no such provision. But if in future we may need to consider that, it would depend. The Standing Commission may consider, offering, allowances and so on. But we have, for the time being, not considered that. Director. Well, if in that case, I also need to make a declaration because I'm also a member of that Standing Commission on civil service salaries. Mr. Cheng Chung Tai. I'd like to follow up on the same topic. I think absolute loyalty under the spirit of the national security law seems to be the overriding principle. Of course, the judiciary will, under the national security law, although I may sound like a spokesperson, but I like to, ask this question. Absolute loyalty, I think it's not possible that you have public officers being paid a very high level of salary, while at the same time the government will think that they have a double loyalty. Of course, judges will need to be professional judges, but many things have happened over the past year. Regarding the question of double allegiance or loyalty, I believe that going forward it will be, a major discussion for the government, including EXCO, the legislature, and even the senior, officers, and inevitably the judiciary as well. So I'm going to ask a very realistic question. At the moment, our judiciary, especially for our judges, what I'd like to know is how many percent of our judges at different courts, in the different courts, have foreign nationality or have multiple nationalities. Do we have such figures? And secondly, is it possible that, of course, under the present regulation, they don't have to declare the nationality of their family members. So to put my question the other way around, for judicial officers, inevitably there might be a problem if the judicial officers have double nationality. So I'd like to go back to my fundamental question. That is, when the nationality of senior officers are a matter of concern, then for the judges, for the nationality of the judges, now under the national security law, this is also a matter of one of the details concerning enforcement. So given the requirement of total allegiance, it would appear that one has to address the question of the nationality of judges. Has the judicial administrator consider that?
If you look at Article 90 of the Basic Law, the Chief Justice of the Court of Final Appeal and the Chief Judge of the High Court shall be Chinese citizens who are permanent residents of the region with no right of abode in any other foreign country. And this is not applicable, this requirement, to other judges. And so they will also, the judges will also will have to, under Article 104, take the oath or swear allegiance to the Hong Kong SAR. And there is no reference material of that that you have mentioned earlier. Well, in that case, I do not know why Junius Ho is just sitting there. I would like to know whether the pro-establishment party should ask for this. There should be information provided to us about the nationality or whether there is double nationality of judges. Will we be able to get that information? Well, Chair, they've never thought, the judiciary never thought that they needed that information. Well, Chair, but I think because of total allegiance that is prescribed under the national security law, this kind of information is necessary and we should have that information. Dr. Kwok, now I think the question asked just now is relevant and it's necessary. The reason why there is a pay rise as proposed today is to chase or to be able to implement the recommendation of the Standing Committee on Civil Service Pay. And on pay, welfare, etc., it's a package. And we have already approved that the housing allowance of judges can be used for purchasing property, houses. And that is to attract more quality professionals in joining and also in remaining in the profession, the judiciary profession. So my question is, with the appointment system for the national security law judges, I would like to know, because after all, the law was not passed until 2 days ago, in the middle of the night too, and it's just been 2 days, so then that is fine. But if you can assess the impact of the national security law on the exodus of the judges or the departure of judges, can you do some assessment on that? And perhaps is it true that this kind of departure of judges had fundamentally undermined one country, two systems of Hong Kong? Have you done that assessment? If you haven't, when will you do it? The second question concerning the selection of the judges under the national security law. If there is a name list of special judges, my question is, under what criteria, what professional qualification or capability? Well, some people say that they will have to understand China's situation. What does it mean? Does it mean that the judges will have to have enrolled in courses in Tsinghua University, or they would have to be able to recite the sayings of some leaders, for example, Zhou Qiang on the rule of law, or Xi Jinping on the state policy? Can you tell us some objective criteria, please? Chair, concerning the second question of Dr. Kwok, and that is what qualifications or criteria should the judges have? Well, according to Article 92 of the Basic Law, it is, what criteria under the national security law? That's what I'm asking about, not the general. These are very special list of judges. And since they are special, they would have some special characteristics. So what are those characteristics? The basic characteristics. No, I'm not asking about basic characteristics. What special characteristics? Now, all right, for the national security law, the selection would be for judges which have already been qualified under Article 92 of the Basic Law. Right. If that is the case, if this is the only criterion, then all you have to do is to pick lots among the judges. My question is, what are the characteristics of these judges? Or rather, what are the criteria for the selection of such judges? According to the stipulation, the CE can ask the opinion of the Chief Justice to select the judges. All right, my question is, what are the criteria? Even though there is discussion with the Chief Justice, what are the criteria? I don't have that on hand. Can you provide that after the meeting? Well, I note the question. I will try to find some information. Right, so they will note the question. And Claudia Mo, first round, 5 minutes. Thank you, Chair. My understanding is that we are discussing the 2020 increase in pay for judges and judicial officers. What about for 2021? Is that survey or study being conducted? And when do we have the results? In the past 3 years, or if possible 5 years, can you tell us the attrition of the judges in Hong Kong? Do you have a percentage, for example? And the judges, basically, their pay, how does it compare, or what is a gap with private practitioners? I'm sure you have such information, right? So 3 questions. Thank you, Chair. First of all, on the attrition rate. According to information I have on hand, the attrition rate is low for judges. Their departure is mainly because of retirement. And in the past, starting from 2014 to 2019, 32 judges have departed, mostly because of retirement, except for 7 who left because of other reasons. This is provided by the judiciary information. Excuse me, Chair. Would you please stop? Chair, you mentioned 7 left because of other reasons in the period 2014 to 2019. And it is not because of retirement. So what are these other reasons, please? Is there a breakdown of the other reasons? I do not have such information on hand, but I can find out after the meeting if I can, because the number of judges is really small in number too, and the departed judges are small in number against the total. Now, as for the pay adjustment, for 2021, according to my understanding, the Standing Committee for Civil Service Pay had already started that exercise, and they will consider the basket of factors set by the EXCO to see for this year what kind of benchmark they will use for the adjustment of judiciary pay. And another question was about the comparison of the different levels of judiciary officers compared to private practitioners in their remuneration. Now, according to the remuneration system, every 5 years there is a benchmarking study. And this year is the year. And therefore, the Standing Committee will start that work this month, and beginning of next year, there will be the result. And the result will be given to the EXCO for discussion. All right, so this is the year, you said. And what about the latest? Chair, what is the meaning of that question? You mean the last study, the result of the last study? Yes, all right. That was the study done in 2015. The different levels of judges, the Standing Committee looks into the past few years, the change in pay compared to the private practitioners' pay was a same differential or gap. And we see that first instance court at the High Court, the judges compared to private practitioners, the gap was some 40% less. And the reports are all public. And that's the finding. And the other levels judges, the gap was not big at all. As for the magistracy, it is minimal in terms of gap. So at the time, the EXCO, or rather the government, having looked at the benchmarking study, had done a one-off adjustment, and that is High Court judges, in terms of their remuneration, they had increased it by 6%, and levels of court under that, the increase was 4%. And as I've mentioned, this year there will be another such study conducted. Chair, if you're talking about judges in the High Court, their pay compared to private practitioners is some 40% less, you say, and then you're saying the government had very magnanimously added 6% to their remuneration. Well, how can you chase back up to the standard? I mean, especially with all this political pressure these days on the judges. I just want to say this point, and that is, for the High Court judges compared to private practitioners, there is such a huge pay gap. And now, with this very heavy political pressure that they have, I do not see how you can retain professionals or talents or be able to attract talents into the judges' pool. So this will be my next round question. All right, Dr. Kwokaki, third round, 3 minutes. Chair, my first question was not answered, and it was a very clear question, and that is, according to the existing situation on the 30th June with the passage of the National Security Law, will there be an assessment of the judiciary to ask the judges of the courts in Hong Kong how they would react to the national security law, such as when will they leave Hong Kong? Will there be such an assessment? And secondly, with the 5.6% pay increase. Now, let's say if they're not even thinking about the pay, and even if the pay increase is over 5.63%, you'll still not be able to retain them. So adding to the pay would amount to nothing. And secondly, with higher pay, you will get the relevant people you want. So some judges may actually respond by saying that, oh, with the pay rise, I will be staying put. Or just now you said that there is a 40% pay gap, and perhaps judges would consider that as well. And we understand the political pressure. Perhaps the judges are saying, no, we can't handle this political pressure, and there is going to be an exodus. Now, if that is the case, then even if we have to increase the pay by 40%, we may have to do so. But we need a study, an assessment before we can do that. And this is different from the Standing Committee for Civil Service Pay study, because the times have changed, the situation has changed. Chair, when I talked about the benchmarking study, perhaps I was not clear in explaining that. In fact, for the High Court, First Instance Court, the judges' pay had always had a pay gap compared to the private practice. But in the benchmarking study, we did not compare the actual monetary amount, because we cannot in one go increase it by a great percentage, but rather we have looked into whether the gap had narrowed over the years or had it been widened over the years, and therefore we will have better substantiation if we need to make a one-off major adjustment if the gap had indeed widened. In attracting quality talents to the judiciary pool, it is not only pay, but there are other factors as well. Exactly. So will you be doing an assessment? Yes, we will be doing an assessment, but we will not only be looking at the national security law, but we will be sending out surveys, questionnaires to the professionals, and we will find out from them what other criteria or what other conditions they need in order for them to join the judiciary. Claudia Mo? Back to my original question. Concerning pay. You are trying to ask a question about the 40% pay gap, is that right? Perhaps when Ms. Mo is trying to recuperate, would you want to respond to her question? Well, sorry, can the question be repeated? Oh, now I can ask a question. High Court judges, their pay is lower than the private practitioners by 40%, and that was a finding in the latest survey. Is that right? So pay is one thing, and now we're saying that with the huge political pressure that is presented currently, I do not see how you can possibly retain talents and at the same time attract new talents to the pool. Thank you, Chair. All along, it is not the judiciary when attracting talents, it is not just the monthly pay that is considered, but there is a whole package, and that is why there is there's an exercise once every 5 years. For example, medical and also housing allowances and their children's education allowances, all these are relevant to the consideration of the judges, especially for the senior legal practitioners, those who join the judiciary ranks later in their professional life. They would consider these. And also the retirement age of judges is now extended to 70 years of age. And so all these are relevant considerations. So the judiciary is actually given better terms than the civil service. And through these means, we try to retain and attract professionals to the judiciary. Well, I'm surprised with that response. I thought she's going to say that this is a sense of mission that it's a calling that people feel, and that is why they join the judiciary. But now you're saying that there are these allowances. Now, I've heard a lot of questions which you have also answered, but I want to clarify one point, and that is about the passage of the National Security Law, which was passed at 11 p.m. At the end of June. And that's just been 2 days that the law had been implemented. And it is true that there are certain stipulations which will impact Hong Kong.
Otherwise, there would not be the need for the CJ, Mr. Jeffrey Ma, to have issued a statement today. But of course, I'm not asking you to provide any footnote to Chief Justice Ma's statement. All right, when it comes to the appointment of judges and also the adjustment, the pay adjustment, well, yes. And I believe you have to find an incumbent judge. I think anyone from the legal sector can also be recruited. So will they follow the same pay? Well, under the national security law, the designated judges by the C would mostly be incumbent judges. If they're not yet appointed, then they have to go through the procedures specified in the basic law. They have to go through a judicial officials recommendation commission for appointment of judges. And after that, under the national security law, a number of designated judges will be appointed to hear national security cases. And their pay will be follow the relevant civil service pay scale. Ms. Caldimo, you can press the request to speak button again, because there is only you present. No, of course, I'm not the only one present. 2 more are here. Now, for judges not yet appointed, I mean, if they're not in the current pool of judges, if they are ordained by the chief executive to be designated judges for national security cases, because I don't know the procedures well. What should be the procedures? Let's say the government favors a certain barrister, and if that barrister accepts the invitation, will he have to cut his private practice? Because I don't know the operation well. He might have left his chambers, but his chambers will not be affected, right? But if that chambers is an associate of barristers and lawyers, what will be the impact? You won't ask the whole chambers to close down, right? Ms. Leung, I don't know whether you're aware of the operation. I don't have such detailed information, but as far as I understand, it is under the basic law, a qualified person, if appointed as a judge, he have to go through the same procedures. First, he has to be nominated by the Judicial Officers Recommendation Committee for appointment by the Chief Executive, and the endorsement of the legislature has to be sought, and then he will be eligible to be appointed as designated judges. But then the appointment is just for 1 year. If 1 year afterwards his appointment is not renewed, what will happen? Or is it guaranteed that once you have been appointed as a designated judge, then your contract can be renewed year after year? Are you aware of the details? Thank you. I'm not aware of the details, but if a judge is appointed as a designated judge, of course he can hear national security cases, and if his designation is not renewed, then he is still a judicial officer, but he cannot hear national security cases. I don't quite get you. Well, Ms. Lang, can you repeat? Now, if we have a designated judge, of course, if he is designated, he can continue to hear national security cases. No, I'm talking about not an incumbent judge who becomes a designated judge. If after 1 year his designation is not renewed, what will happen? Ms. Low, my understanding is that the pool will come from incumbent judges before they can be designated judges under the national security law. It's not that any other anyone who is not an incumbent judge can be designated. 2 minutes. Because I heard just now that someone outside the judiciary can be appointed. For instance, someone with a low acceptability can be appointed or designated. Because you didn't correct that saying, I thought that someone outside the judiciary but in the legal sector could be designated, could be appointed to be a judge and designated to hear cases of national security only. But the appointment will only be for 1 year. Can that be renewed? Now it turns out that my questions were not really necessary. So the CE can only designate judges from the pool of incumbent judges. So the questions I asked were totally unnecessary, right? Ms. Low, I can only answer questions according to my understanding of the provisions. My understanding is not that someone who is not a judge can be a designated judge. The procedures specified in the basic law have to be followed. Now, this is exactly my question. Let's say there is a very senior solicitor, not necessarily a barrister. Then under the basic law, there are procedures to follow. Once he is recommended by the JLC, then he can be a judge. Can he be designated to hear national security cases? Now, you sometimes told me that there weren't such procedures, and sometimes you told me that an outsider could not be designated. Now, what I said was he had to go through the procedures for appointment to be a judge before he could become a designated judge. Exactly. If after 1 year his appointment is not renewed, can he return to the private sector? Have you heard Ms. Mo's question? Do you have anything to add? Nothing. Any other questions from members? If not, I'll put this item to the vote. But we don't have a quorum here. All right. Ms. Claudia Mo claims a division. The division bell will be rung for 5 minutes.
好啦，都3分鐘啊，同
It's been 3 minutes. May I remind you that we are voting on paper FCR 2020-21-12 to invite members to approve with effect from the 1st of April 2019 an increase in pay by 5.63% for judges and judicial officers.
其實好齊人嘅，大家都喺齊度。好，請各位表。
Please proceed to vote. Please check your votes. Voting is closed. I'll display the results. 40 present, 22 for, 12 against, 5 abstentions. I declare the motion passed. The next item is FCR 2021 and also FCR 2020-21-14. Both papers are related to extension of maternity leave. To save time and to avoid repetitive questions, I will have a joint discussion of the two papers, but they'll be voted on separately. The first is FCR 2020-21-21. Members are invited to approve a supplementary provision of $161.7 million in 2020-21, an annual recurring funding of $524 million in 2021-22 and onwards to implement the reimbursement of maternity leave pay scheme by appointing a processing agent. The Labor and Welfare Bureau has consulted the ESC on the extension or reimbursement of maternity leave pay leave, and the ESC spent about 55 minutes to discuss this. Another paper is EC 2020 FCR 2020-21-14. To discuss EC 2019-2022, members invited to recommend to the FC the creation of a Chief Labor Officer with immediate effect upon approval by the Finance Committee. And the ESC spent 1 hour 22 minutes on this item. To answer members' questions, we have Dr. Law Chi Kwong, Secretary for Labor and Welfare, Mr. Carlson Chan, Commissioner for Labor, Mr. Raymond Ho from the Labor Department, and Mr. Raymond Liang from the same department. Can I now invite Mr. Vincent Chen, Chairman of the Manpower Panel, to brief members on the deliberations? Thank you. We discuss this item for development of an information system to discuss to carry reimbursement of maternity leave pay scheme. We have no objection to submitting this item to the FC. Some members of the view that when it comes to the development of the system, it will only take effect later. Now, it is expected that the reimbursement can be implemented by end 2021. Members asked the members to shorten the preparation time and also to compress the time for developing the system. And according to administration, they're working against a very tight time frame. And members asked that when the paper goes to FC, the recurrent staff expenditure and also the time for developing the system should be given, or we should be given extra information on that. Mr. Vincent Zhang, 5 minutes. Thank you. Thank you. As I reported, the Manpower panel discussed the arrangement. In principle, we want the extended statutory maternity leave to come into force, but in the coming legislative sitting, we'll have to continue our scrutiny of the relevant bill. So we hope to pass the bill as soon as possible next Wednesday. Now, the Secretary is seeking funding even before the bill is passed. Now, we have only 2 weeks left in this legislative term. What if the bill cannot be passed before the end of the term and the funding is already approved? And then I understand that you would like to outsource the development of the system. I hope you can do so, but is it true that you can really do so by the end of this year, given that it is already July, you've only got a few months left? Now you are seeking a large amount of money for the system, and we hope that we don't have to wait 18 months, so just 6 months we can have the system up and running. So can you guarantee that you can do it before the end of this year? Now, if FC gives us the green light today, and if the bill is not yet approved, in fact, we have to wait until the bill is enacted. We cannot start our work before the bill is enacted. And the second question is, we will try our very best to do it, because usually the tendering part will be most time consuming, and we are already doing the preliminary work. As soon as the funding is passed, we will go ahead at full steam. Now, if we can outsource the work successfully, usually if it is for the government to set up its own system, now we have to conduct a tendering exercise and employ our own staff. In the past, it would take us 18 months. But after we have outsourced it to a processing agent, then it can be much faster, because they do not have to go through our tendering procedures. We hope that in the first half of 2021, we can start the reimbursement of maternity leave pay. Once the bill is passed, the total stretch of ML will be 14 weeks. So it will be about 3 months after the passage of the bill when people will apply for reimbursement. So we hope that we can develop the system before the bill is implemented. So I believe we can be 1 year ahead of our original schedule.
I hope that by next Wednesday we will be able to complete the scrutiny of the bill. If during the current term we can complete the scrutiny of the term, that we can't, then we have to start again. So we have several tens of thousands of moms, parents who have to wait longer. So I hope that the ordinance can be passed ASAP. Now you're now resorting to outsourcing. Now, other than this will take less time. So, what are the other advantages? I think we're talking about outsourcing here, but the major consideration this time is speed. if we could respond to the aspirations of elected members and society, if we have to wait until the end of 2021, that would not be so acceptable. So by outsourcing, we hope that the whole process can be expedited so that we don't have to wait for too long before the implementation of the ordinance. Of course, another benefit of outsourcing, like all other forms of government outsourcing, so for in future for the adjustment of our system and our I think the time required for upgrading will be faster. So if it were done internally by the government for any major enhancement, it would take longer. Ms. Dr. Helena Wong, your first round. Thank you. Chairman, we have a timing problem here because in electrical we are now, dealing with the second debate of the bill on maternity leave that has yet to be completed. We can only, continue to deal with this next Wednesday. If the bill is not officially, enacted and becomes law, so even if we successfully amended this ordinance and we now come to FC for funding, so for our legal advisor, I'd like to ask whether or not we are jumping the gun here. Although the Secretary said that today, even if we approve the funding application, we won't do anything yet until next week. I'd like to ask whether we have any precedent that is before the, so that is for, have we had any precedent that funding approval was given before the legislative amendment was approved? Ms. Wong. I think at the establishment committee meeting, this was already deliberated already, and so I wonder whether the Secretary would like to tell us what are your thoughts on this. This may not be a question for our legal advisor, because this is not really related to the bill, but I think it's relevant because the bill proposes to extend the maternity leave from 12 to 16 weeks, and this is expenses arising from the extension. Dr. Law. Mr. Lau, Deputy Secretary, thank you. We are now applying for funding pursuant to the public finance ordinance. Normally, for certain items, when we submitted the budget, if we could budget for that already, we already have included it in the budget. And such funds may not be immediately used. We may have to wait until a particular ordinance bill is passed before we would use it. But in this case, we did not envisage that this amount will have to be expended, and that's why we are now applying for supplementary funding. Like the Secretary said, the funding will only be used after the bill becomes law. In respect of, the funds will only be used subject to certain conditions, and this has always been the rule all along. Dr. Wong, all right? My next question then is that regarding the agenda of the FC, I think we can actually postpone this item on our agenda and wait until the bill is officially enacted and becomes law before we deal with this. I don't understand why the chairman has not talked to the government about this, because all these are based on assumptions, assuming that the amendment is approved and there are no further hiccups, and we are now asked to endorse this funding application. I think if we could actually postpone this a little bit, we don't even have to ask this question. So I think there is a problem here, because many of the things here are based on assumptions. Now, first of all, I think the government cannot envisage that we've taken so much time to deliberate on all these items. So they might not have envisaged that we have actually approved some of the earlier items earlier. Mr. Lau, like you said, when we arranged for the the agenda, it was difficult for us to predict how much time it would be required for that item to be approved, and that's why we have this time gap here. But what we like to say is that even after the funding were approved, we still have to wait until the bill is approved before it could be used. I believe the Bureau can also make that commitment. Yeah, I think that is the case. I confirm that is the case. Dr. Wong, any further questions? Okay, I still have time. You're now contracting this out to a processing agent because it would expedite the whole process. Have you actually sent out the tendering document yet? Not yet. We haven't completed the relevant procedure yet. If Dr. Wong has further questions, you can wait for your next round. Mr. Kok Wei Kang? Thank you. I think the extension of the maternity leave, I think this bill was discussed at the council meeting last week, but there was numerous calls for, a quorum, and there was a deliberate attempt to abort the meeting because people asked for, I think the people who asked for a division deliberately stalled the meeting, and many from the pro-government camp were actually still within this council building, but so it shows that they were deliberately trying to abort the council meeting. So with the 2 weeks remaining for our council meeting, whether or not we can complete the scrutiny of the bill extending the maternity leave, of course there could still be people deliberately trying to abort our meetings. The meeting was not completed last week, and that's why there is a delay of 2 weeks. On the one hand, some people ask people to actually implement the proposed extension of the maternity leave in order to benefit the pregnant women. At the same time, they say there's no harm in stalling this. So we're also concerned about several other points. Now if the bill were not passed, then the funds cannot be used. So the so-called jumping the gun is actually not, a real issue. So if we endorse it here, then it will expedite its approval in the council meeting. Many members have spoken already on this bill, and so far no one has lodged any objection. Is it that there will be people who would be lodging objection to the proposal? I don't think that there's any ground here, because the government should already heard all members' views on this, so I don't think we need to dwell on this any further. So originally, the implementation of the extension of the maternity leave will have to wait until the end of next year. But since the government has changed its strategy, it's not going to set up a new department. Instead, it's going to resort to an external processing agent, and that's why it's possible that by the end of this year, this could be implemented. And that is good news. But given the current situation in Hong Kong, if we were to outsource the service, you still need to call tender, and that will take some time. And a lot of preparation will need to be done. So do we really have to wait until the council has actually passed the bill before you will call tender? Or is it that you could do it a bit earlier so that we can actually ensure that this will be implemented by the end of this year rather than wait until the end of next year? Is there any way you can ensure that the scheme could be implemented ASAP? Dr. Law, Chairman, in theory, the tendering, we will follow the proper procedure to call tender before the bill becomes law, and if the funding is not approved, then we cannot sign any contract. However, if the bill cannot be passed during the current electrical session, I believe that the tender will be called off because there is an effective period for the tender. After the bids have been put in and if the bill has not approved, what should we do? If the bill is not approved, I believe that all our preparation work will have to be, put to halt. So I therefore hope that members will, approve the funding application and also approve the bill ASAP as well. Of course, if we support the extension of the maternity leave, then I don't think we should stir up any controversies and try to, impede the process. I believe it is the aspiration of the Y community that we have this implemented by the end of this year. Claudia Mo. Thank you. In scrutinizing this bill, pretending that we are the Bills Committee, at the time the understanding at the beginning was that to develop the system it would take 18 months. That's really scary. We thought that we're now in the IT age. If you say it takes 6 months, I would say it's reasonable. If it takes 1 year, I will reluctantly accept that. To say that it would take 18 months is really an exaggeration. You now tell us that in order to expedite the whole process, you need to outsource. The so-called $524 million. Is that the extra amount we have to spend? Because originally, if we were to do it in-house, using the government's own system, then it would have already been, included under the usual government, expenses. So the $5 million, would that be a net increase in expenditure, or you may also have to deduct the amount which you would otherwise have to spend anyway? I think the $524 million we say in this paper would be the additional expenses to be incurred to implement this reimbursement. In preparing for the extension of the maternity leave, the Labor Department had also hired additional staff, and those expenses have also to be separately, calculated. We're talking about the principal labor officer post. Now, when we scrutinized the bill, the officials attending the meeting swore that for women earning, there's a cap on the women at $36,822. So it's all based on science because you have such an exact amount as a threshold. And we said that you are actually discriminating against women earning higher salaries, setting the gap at $30,000. Honestly, for our pregnant women, they're normally younger in age, and the salaries may not really be too high. Why are you so scared? And the officials swore then that you need to, be prudent in spending public money, and that you cannot, spend money, lightly, and you swore that that was the policy which cannot be changed. And one of our members said that you should, set the threshold to $100,000 a month so that you will be able to cover all the women who would benefit. And you say that would not be possible. But when you took the bill to the council, you actually adjusted it from $36,000 to $80,000, although it's still less than $100,000. But for me, it's already, the right thing to do. But I think, it was very bad in terms of perception. Originally, you stubbornly refused to raise the threshold, and subsequently you feared that the pro-government camp might put pressure on you, and all of a sudden you suddenly agree to top up the threshold. Normally we thought you will raise it to 50, but now you raise it to $80,000. So what has happened during the interim? You're creating the impression that you are being very hypocritical. You are just to ensure that the bill is passed, or actually it will be passed anyway. I don't know whether you were kidnapped or held hostage. You immediately raised the threshold by more than 100% or 200%, or not yet 200%, or close to 200%. So what really happened? I think on Wednesday when I give a response in the council meeting, I will give a response. But to give you a simple answer, we've listened to the views of the community and adjusted the ceiling of the monthly salary to $100,000. And in 4 weeks, it's roughly about $80,000. We thought that we could accept that suggestion. Nobody is holding you hostage. I don't see how anyone can hold the government hostage. I'm talking about yourself. I think the Secretary has already responded. Mr. A. Chen, Chairman, I heard the FTU members saying that we are stopping the passing of this bill, and I really that reminds me of Mr. Wong Kok Heng, who was very much against filibustering. Of course, he subsequently lost the election, but he was very serious. He've actually done a detailed calculation and told us how many cans of luncheon meat were actually, forgone. So before that we finish, Andrew Leung already resumed the meeting. You want to go fight against filibustering? I don't think you've seen real filibustering yet, because in a filibustering process there will be adjournment and so on. Of course, the Secretary, you may not have to answer my question, otherwise you would be, speaking against the pro-government camp. Now, to complete the third reading in 2 weeks' time, there is also the full council meeting yet. We don't have any council sitting this week, and because of that, we have a finance committee meeting. If we have a council meeting today, there wouldn't be a FC meeting. Next week, I think it is expected that this bill on the extension of the maternity leave will be passed. But can you tell us that you are confident that we can finish the third reading in 2 weeks? Well, I hope that the bill will be passed as soon as possible, and that's why last week I thought that the bill would have been passed already last week. So, like the FTU is saying that even if if it is delayed, extended by a week, what will be any unforeseen circumstances? The Secretary said that during the resumption of debate, you said originally you thought that this could only be implemented by the end of next year, but now you say you can do it by the end of this year, and hopefully, if the bill were passed before the end of the summer vacation, then this could be implemented by the end of the year. I've read reports that you've learned from the experience of the employment support scheme that the scheme doesn't need to be very complicated. People will give you the information and you will reimburse them. Is it that originally you thought that this scheme is too complicated, you need a very powerful system, and it will take you a year before you can implement this by the end of next year? When did you suddenly realize that in the light of experience of the employment support scheme, which went very smoothly because people received the money very quickly, and based on that, you come to the conclusion that this could be done very quickly?
Chair, for the adjustment, it is because we believe that with the tendering out of the work, we'll be able to expedite the process. And when the law comes into effect, it will take a bit of time for the employers to be able to effect the reimbursement. So if you remember, in the budget of 2018, concerning the $4,000 care fund, it was not until 2019 that there were applications made. So it was 17 months it took in total. And then the FS, in his first announcement of the first round of alleviation policy, the N-nil persons application also took 12 months, about 1 year. And this is not really a one-off exercise. It is about an ongoing work. So the tendering process may take a little bit longer. And there are a lot of procedures that will be involved. For example, we need a big group of people to vet these applications for reimbursement of maternity leave pay. Then we need to talk about not only the testing of the system, but also the finding of the people and interview of the people to man this team. So that took 18 months in our estimate. Chair, Mr. Law had talked about one-off many times just now. I just want to know, when they had changed their mind. Mr. Law, when did you change your mind about the time needed? Well, I think it was in early April that we came up with a scheme, and it was in the third week of May that we started the application for the ESS. So that also was relevant information for us to take into account concerning the timing. Fernando Cheung, I'm very happy, Chair, to hear that this is much expedited. I was shocked when we heard earlier on that it took 18 months. How complicated was the system going to be, we thought. So with this proposal now, with the tendering out, the time needed would be much shortened. Now, you can think about the original proposal of 18 months. Even when you made that proposal, you weren't thinking that the Labor Department, your own officials, will be developing this system, right? So I'm curious to know this 18 months, which is now shortened to implementation by the end of the year, and we're already now in July. So that means 6 months. Within 6 months, which is 1/3 of the time of 18 months, you'll be able to complete the system. What caused that change? Now you're tendering out, and this tender out cost is higher than you had estimated, and you can find much more efficient outsourced companies to take up this work for you. But on the other hand, the bill is not passed yet. The funding is not approved yet. So my question is, Mr. Law, can you enlighten us? Why the sudden change in terms of the timing? How did it come by? Chairman, actually, I think I've answered that question earlier. The tendering will take 6 months or so, but of course we will do all the relevant preparation and complete that work. Now, if the outsourced company takes up this work, and even if the outsourced company is taking up this work, but they may still be outsourcing or tendering out part of the work as well. But this tendering out is very different from our tendering out the work. Why? Because we have certain bottlenecks. We have to recruit the right people, the team, and we have to have the office for housing them. According to my understanding, the agent had used over 200 members of staff. If we use government procedures to recruit 200 members of staff, then it will take time, and also we will need 20,000 square feet of office space. So if you think about the care fund, as I've mentioned, it was in March of this year that we found the office space and then it had to be renovated and fitted out, and it was only very recently that the training was done for the staff, and therefore it was only very recently that we had started accepting application for the N-nil persons. So given that experience, we know that the private sector will be able to expedite the process a lot more. Chairman, I don't think Mr. Law heard my question. My question was, even for 18 months as originally proposed, it was not conceived that this will all be done in-house within the government, right? For this reimbursement mechanism, it's never intended that the government will develop its own system for doing that, right? It was to be outsourced from the initial conception, right? But now all of a sudden, the time needed is shortened from 18 months to 6 months. And just now, Mr. Law, in his answer, gave us a lot of details, but my question is, it had always been intended to for the work to be tendered out. So what was the turning point? Why do you think that the time needed is shortened by so much? Mr. Chair, I think there's a misunderstanding. The system includes a very big office. It includes a very big team of over 100 people. And now all this is tendered out. Fernando Zhang was just talking about the computer system development. Yes, the development of the system, or the computer system, will of course be tendered out. But still, the whole process will be a lot longer than tendering out the whole work. Now, 6 months is needed to do the tendering work, and the winner of the tender will be able to complete the system and complete the reimbursement mechanism in 3 months, with 3 months of work. Xiu Ka-chun, the proposal from the government is for us to approve a supplementary provision of 165.7 million and an annual recurrent funding of 524 million to implement the reimbursement of maternity leave pay scheme by appointing a processing agent. I have certain concerns about that. First of all, the processing agent funding, and that on itself, and also there will have to be administrative cost. We're talking about the benefits to the pregnant women, but at the same time it will hurt the interests of other sectors of the community in Hong Kong. So given this, I have a few questions. What is a reasonable level of service fee for the processing agent? And secondly, how many employees are we talking about for the reimbursement mechanism? In the original estimate, how many civil servants would be involved in the reimbursement mechanism? And another question, what about the employees' protection, their leave, their pay, their time of work? Are there, for the processing agent, is there any protection in these regards for the staff of the agent? We don't want them to be exploited. Mr. Chair, if you look at the paper, there is a budget which is the 10% of the cost as that will be the service fee. And the whole thing will go through a tendering process. So at this point, it is very difficult for us at this point to say what the actual fee or cost will be at the end of the day. For a lot of the other services, it will be about 5% to 10%, and some are much higher. If you think about, for the universities, the administration fee can be 10% or even 20%. So based on this and with the tendering process, we believe that we should be able to keep it within this level. As for the staffing, the processing agent, they will have to budget for human resources, whether they will use AI, etc., to know how many staff members they need. And they'll have to specify that in the tendering document as well. But this is not like cleansing work. It's easier to foresee how many people, staff members they need. But for standard contracts such as this, or standard contracts are easier to foresee, but we do not have any requirements here for this contract because the staff would mostly be professional staff and not general staff. And also the processing agent would probably be a big organization with a lot of experience and well established. And for such companies, we believe that they would treat their staff well. Chairman, there's another question I asked which was not answered, and that is, in the original conception, how many civil servants will be deployed to take up this work? Perhaps Mr. Chan can answer that question. Yes, since the decision of the government to tender this out, the Labour Department had not very seriously gone through the estimate as to how many officers we need to take up this work. But if we refer to past experience in related work, for example, for transport subsidy 2 years ago, that was work taken up by the Labour Department. And for comparison, I'd say for the relevant number of applications, similar amount of applications, we deployed 200 staff members for that work. But as mentioned just now, we have not done deep analysis as to how many people we need if we are to retain this work within the government, because we have decided to tender this work out. 4 minutes, Helena Wong. Chairman, we are also discussing the creation of a new position, right? Can I ask questions about that? Yes, you can proceed. All right, for tendering of the work to develop the system, and then after that to reimburse the maternity leave pay through the employers, my question is the right of ownership of this developed system. Who does it belong to? Who owns that right? The developer of the system, or would that be transferred to the Labour Department or the government? That's the first question. Second question about the creation of the post. I do not understand, because if this is mainly work undertaken by the outsourced company, and there is already a system, then why do you still need a principal Labour officer? Well, fetching over $100,000 per month by way of salary. And it says to improve on the new measures of the maternity leave pay scheme. Well, I don't understand, because the work has been tendered out. Why do you need a high-level post to look after this work? Can the government please answer the questions? Chairman, concerning the computer system, we will have to consider the details, how the system is to be operated, and the ownership. Perhaps we will consider this in detail further. But of course, if the system is a straightforward one, then perhaps the government does not need to own it. But the information, data, of course, will be owned by the government. And we will have to look at or seek a specialist or expert opinion on that. Secondly, on the position to be created. The work, even though it is tendered out, the responsibility still lies with the government. It's just that the processing agent will carry out the work, that's all. So the government will still have to come up with requirements and specifications, and we still need a high-level person to monitor the work. So this position is absolutely necessary. Chairman, in that case, this person will be monitoring the work of the processing agent. Is that how it works? I mean, you have a lot of colleagues within your department, the labor department, right? And we already have the mechanism for the system for reimbursement of the leave pay. So what does this person do, this newly created post? What does a person do? Chairman, you would understand that many departments will have outsourced work. And for the person who is responsible for outsourcing the work is the principal assistant secretary. But the position we are creating is not really overly high, and the person does have to take up monitoring work because this is a responsibility that rests with the government, and also there is employer responsibility as well. There would be legal implications as well, and therefore we need a high-level officer with actually very serious responsibilities to take up this work. Fernando Cheung, apart from him, any other members who would want to ask questions, because we will need time for voting by division. And if there are a lot more questions, then we will have to close the meeting and have the questions continue tomorrow. Otherwise, we will... Oh, no, this is not time for voting just yet. No, Chairman, I'm just concerned. We should close this meeting 6:30 p.m. And I see that a lot of members have already left the building. If we are to call a vote, I fear that we do not even have the quorum. All right, if that is the opinion of Mr. Wong, and also we have further members who would want to ask questions, then we will resume this item tomorrow. Let's just resume this item tomorrow. We end the meeting here now. Thank you.